Well, thank you all for joining us today for today's session, and welcome again to SWIFT 2020. I know that Justin gave a great introduction a few minutes ago during Helen's keynote, which was fantastic. So hopefully you were able to join that. Before I introduce your speakers to you today, I'd like to cover just a few housekeeping items. As you're joining, you should see a quick poll question on your screen. If you'd like to submit an answer, please go ahead and do so now. Secondly, please note that the views expressed here today by the speakers are their own and not of their organizations. And then last but not least, we hope these sessions will be interactive. So please submit any questions that you may have. You can do so through the chat feature in Zoom. And to make it fun, we will give the first 5 participants who do submit a question a t-shirt. So now that we have covered that, let's move on to our panelists. So we have a really fantastic lineup, and we are very grateful that they were able to join us today. So the panelists today are Julie Brill, who is the Chief Privacy Officer at Microsoft, Keith Enright, who is the Chief Privacy Officer at Google, and then Bruno Giancarelli, who is Head of the International Data Transfers and Protection Unit for the European Commission. Moderating today's session will be Justin Antoni Pillay. Justin is the founder and CEO of Wirewheel and is recognized as one of the leading experts on privacy and data protection. Before Wirewheel, Justin served as acting Undersecretary for Economic Affairs at U.S. Department of Commerce during the Obama administration and led a number of high-priority international efforts around privacy and security, including leading the U.S. negotiating team and reaching the EU-U.S. Privacy Shield with Europe. So I'm excited to welcome you, Justin, and I will turn it over to you to further introduce our panelists.
Sarah, thanks so much. And Keith, Julie, Bruno, great to see you all. I thought, well, my sense is, Keith, Julie, Bruno, that most of the community knows you. And obviously, with the brief introductions we've already had, we know that you're leading enormous privacy organizations and a number of large dialogues. So today, given that we only have about an hour, I thought I'd jump right in and start a little bit of a conversation on a number of different subjects. And let me just say, it feels like the last time I saw you all, it was another century. It's only been a few months, but we've seen the entire country shut down. There's obviously been very significant civil rights movements and things coming to the forefront every day. So there's a lot to talk about. I'm going to start today with just a little bit of a conversation around COVID, reopening, and privacy. So, for each of you, I know you've thought about the broad set of issues that are on the minds of the huge privacy community, and you can see we have hundreds and hundreds of people joining us today. But these issues are also on the minds of the public. It's on everybody's mind right now. I'll tell you myself, I was just talking to this about Helen. I'm getting emails from almost every organization, including little leagues, asking me to personally sign and present medical information just in order to have us participate in a little league practice. And the forms of it make you feel two things, or at least make me feel two things. One, it seems very arbitrary, and I'm not a scientist, but it seems like unclear to me how a little paper I sign is going to have any effect on protecting public health. And two, it's from a privacy protection side, it really worries me, because if it's happening in that kind of an ad hoc way, just as a human being, you can imagine how this could proliferate. People emailing around, I heard Bob has some disease, makes me really worried just as a person that walks the earth. So Julie and Keith, I've seen you both publish and speak extensively about this issue, how to think about it at the principles level. And both of your companies are also providing solutions. And no matter what you do, I think you have been criticized from each side, either too much data or too little data. And in parallel with that, obviously, Bruno, all 28 of the member state data protection authorities and the commission are issuing guidance So I know you're all thinking about this day to day. So let me start with you, Keith. Google has released COVID tracing technology. And I think it's fair to say that no matter what, there was criticisms about too little data or too much data for the approach that Google offered. Could you give us a little bit of guidance based on your experience so far in terms of trying to tackle some of these issues? What is the solution you've put out there, and what have you been hearing about it from the community as you put that out there?
Sure. I want to be sensitive to time because we could easily burn through all the time we have left and more just talking about exposure notification and kind of how that's playing out. But to abbreviate it to the highlights that I think will be useful for this audience. Yeah, as I think is generally understood, we've done historic collaboration with Apple to try to leverage our technical strength to provide exposure notification capabilities to national health authorities. Now, there's one important clarification that I think we need to make, which is we are not doing contact tracing. We're not providing contact tracing. So the semantics here are actually quite important. Contact tracing is a methodology that goes back hundreds of years that public health authorities have used to try to contain outbreaks with various kinds of features. I was just learned this morning, actually, on another webinar that it was what identified the original typhoid Mary in the typhoid outbreak. So that is a well-established area of epidemiology. They have that bit figured out. What has not really been done very effectively before today is how do we leverage the benefits of new technology to expand the scope, the velocity, and the effectiveness of traditional contact tracing approaches. That's what we've really tried to dial in on. And I do think it's important from a privacy perspective to get some sense of the problem we recognized in the way that we approached it. So when COVID-19 was beginning to bubble up, we had a lot of interested parties coming to us asking whether location information sourced from people's cell phones would be useful in helping to contain the pandemic. And candidly, it wasn't. Like, one of the challenges we had is we didn't have the scope. The data is not reliable enough. It's not precise enough. It was not the right data set to supplement traditional contact tracing. But a lot of thinkers inside and outside of Google had this epiphany of thinking, well, maybe we could repurpose Bluetooth proximity technology, which had never been used for anything quite like this, but which might be useful in gaining some sorts of risk insights that would enable national health authorities to do some things in the context of contact tracing that would actually ultimately be useful and help drive better public health outcomes. So that's what we focused on. And as we leaned in on that and we engaged with health experts, we engaged with cryptography experts, privacy experts, policy people all over the world to understand the contours of the space that we were stepping into. Of course, we anticipated that everything we do is going to be strictly scrutinized, right? We are at the center of this conversation for a whole bunch of reasons, and we knew that we were going to be held to account for doing the right thing here. So we tried to orient as strictly as we could to privacy by design as a first principle in what we were doing around these APIs. And that sort of resulted in the beginning stages of the conversation. There were three things we needed to account for. And all three of them are somewhat separate, but they also sort of run in parallel. One was, there's a technical problem. Can you use Bluetooth to do the thing that we were trying to do? So the engineers were set to work trying to sort that bit out. There was a philosophical challenge, right? Which is, to what extent do you want to enable data collection? Who do you want to make that data available to? And where should the key processing occur, either on device in a distributed way or via some centralized servers? And then the third and last bit is efficacy. Like, how do you determine that what you are doing is actually driving better public health outcomes? So all of those things have been challenging. We've learned a lot all the way through. It looks like the technology will be able to do some of the things that we're hoping it will be able to do. The debate around a distributed model versus a centralized model continues to play out. We and Apple committed firmly to the decentralized model for privacy protective reasons, and also because we feel like we can drive the best possible public health outcomes. We don't think we're compromising efficacy by relying upon this distributed model, and most of the academics and specialists who have been conferring with us seem to support that model, but there are others who disagree. There are still some national health authorities who believe that more centralized processing is necessary for them to do their jobs as well as they possibly can, and we'll see how that plays out. You know, we've tried to make it non-contentious. These are very thoughtful, respectful people on the other side of the conversation who actually believe they can do their mission better by taking a different approach. We disagree. We're doing the best we can, kind of be accommodating, but for privacy purposes and for efficacy purposes, we've been committed to this decentralized approach. And the next chapter is still in front of us, right? The efficacy of this thing is unknown. The APIs are now publicly available. We have multiple apps that are now out in the wild. The national health authorities have worked with us to get approved. We're beginning to sort of see the kind of data that's coming back from these to see if it will drive better public health outcomes. And hopefully we'll see more engagement. As you said, one of the greatest challenges we have here, the biggest riddle still to be solved, is how do you build user trust so that they choose to voluntarily download and install these apps and provide consent for the data sharing with their national health authorities to allow contact tracing to be as effective as possible. That's a very hard problem to solve. It's very complicated. And primarily that's going to be the remit of the national health authorities themselves. They're going to have to work within their jurisdictions to do that. We're here to help. We'll do whatever we can, but that's appropriately their relationship with the people within their jurisdiction. We're just going to try to give them the best tools available.
Yeah, Keith, I mean, that you can tell we're going to run. There's so much to unpack there, and I'm going to come back for a little bit of a discussion in a moment, but I'm going to turn to Julie for a moment. I read, it was a terrific, nice, crisp piece, Julie, you and your colleagues have written around thinking about the principles around COVID tracing. And I'm going to use the terms, I apologize. There's some is contact tracing and collecting data that can be used for that purpose. So I don't want to conflate them. But even the sources that we're seeing that companies are collecting, even if you try to keep them compartmentalized to prevent re-identification, it's very sensitive data that you start seeing coming in passively. And so, Julie, I'll give you a chance to just cover some of the critical features that you're thinking about at the principles level. But of course, a lot of us also think you're putting companies into a position where you're, even for a short period of time, in possession of highly, highly sensitive, even if compartmentalized information that could be called for access by, you know, law enforcement or other purposes. So
let me jump in for just one quick second there, Justin, because like what you just said is categorically false. Like this thing is actually designed so that neither we nor our counterpart actually have access to any of that data. We don't see it, it's encrypted. Like the national health authorities will have access to it, but by design, companies will not.
I apologize, Keith, and I'm sorry. So by the way, you're right. I wasn't in that moment talking about the Google solution. What I had pivoted to, and my apologies, was a broader piece about some of the ways in which companies are trying to collect information from their employees as you open up. And so my apologies for that. You're right, because I sort of shifted from the Google solution or some of the Google technology to the broader technologies that companies are trying to think about. And the context of Julie's piece was in that context, not on the Google solution. So thank you for calling me on that. But Julie, I might pivot over to you on some of the principles you had talked about.
Sure. I mean, obviously what Apple and Google have built is, I agree, it's historic. And I think that it's going to be, potentially incredibly powerful and helpful. There are other technologies out there, as we all know, both in terms of exposure notification, proximity notification. There's all sorts of types of tools. And so I think to take a step back, what we all need to realize is privacy is more important now than it ever has been. Data is going to be used and should be used to help solve the COVID crisis. There is incredible value in data, and it's not just in terms of individual, sort of augmenting and bringing into the 21st century, the centuries-old process of contact tracing, but it's also data is going to be needed to develop vaccines, to develop treatments, to figure out where ICU beds are at capacity or not at capacity. I mean, there's all kinds of data, all kinds of logistics. Some of it will be personal data and some of it will not be personal data, but we're going to need to rely on these systems and these data systems now more than we ever have. And because of that, we need to ensure that privacy will be protected, because a lot of the data, particularly data that is going to be used to try to mitigate the disease in terms of when one person is infected, figuring out how to ensure that those people that were in contact with that person are tested, and so that we can really contain the disease in terms of ongoing waves. That is the kind of data that could potentially be deeply sensitive and clearly needs to be protected. In terms of who's at risk, what we've seen over the past several months is that there are vulnerable populations that are even more at risk than sort of your average or the full population. And particularly what we've seen in the United States is that the African American and Black community, the Latino community, and Brown communities have all been deeply affected, more deeply affected than their population would, just as in terms of numbers, would appear to warrant. So from our perspective, data is going to be really important to help those communities in particular, as well as, the broader community. But when it comes to vulnerable populations, also the elderly, we're going to really need to use data to help contain the disease as much as possible. That means trust absolutely needs to be a big part of this, which is why you need to have principles. And some of those principles are going to have to include for the kind of sort of general public exposure notification and proximity notification systems that, we've been talking about. Absolutely, these are going to need to be voluntary. If they're mandatory that people download the app, there's going to be a lack of trust. There needs to be clear transparency. People need to be told what the data is and how it's, what data is going to be used. It also needs to, in our view, be controlled by public health authorities. That is, the apps themselves should be based upon public health authority criteria in terms of how long data needs to be collected, what are the proximity metrics that you're going to use, and it should be public health authorities that decide, when the apps will issue notifications or will issue some kind of a contact with other potentially exposed people. We absolutely, to the point about how data could get into the wrong hands. I mean, I completely agree with Keith with respect to the system that that Google and Apple have built. But with respect to all systems, we need to make sure that this data will be subject to strict purpose specification for the privacy geeks out there and strict data minimization. So the data cannot be used for anything other than public health. It can't be used by, to identify protesters. It can't go to law enforcement for criminal investigations. I mean, this is data that should only be in the hands of public health authorities. And when it's no longer needed for the public health crisis, it should be deleted. It's really critically important that we put guardrails, whether we talk about legislation or before there's ever legislation, as these systems are being built and as companies are launching them, and as more importantly, public health authorities are launching them, we really need to be sure that we have appropriate guardrails in place so that privacy and civil rights of end users are protected.
Yeah, Julie, I appreciate you covering that. And again, Keith, thanks for covering that, because that piece about how do you make sure that the data is not used for other purposes once you start collecting it is a tricky one in the absence of legislation. It just is. It's not that it can't be done. It's not that you can't put guardrails, but it's one of those things that I think a lot of us are trying to figure out right now. And you've seen different folks thinking about different approaches to that. I want to turn to Bruno for a moment. Bruno, it looks like, as I mentioned, there's been a fair amount of guidance that the European Commission and the DPAs and the EDPB are issuing. Have you seen consistency across them as a general matter? And how is Europe thinking about it in the same way that it's been sort of framed up by Keith and Julie so far?
Sure. And first, thank you for having me. Hi from Europe. It's good to be with you and with your audience, even if virtually and remotely. At the beginning, the privacy community or the privacy or the data protection authorities community is no different from other communities. At the beginning, there was a sense of shock, of panic, given the magnitude of this crisis. And there was indeed, there was a tendency at the beginning to go in different directions. And this crisis has been a sort of stress test, of test case for not only the GDPR as a baseline legislation, but also its governance system. The way the European DPAs have to work together to ensure a consistent interpretation of those rules. And I must say that after some time, it didn't come immediately. There has been a realization that, working together and developing a common guidance for Europe was essential. And that has, to a large extent, worked. There was an interesting, and we work well with the EDPB, a sort of distribution of work and of roles between the Commission on one hand that adopted guidance on tracing app, and the EDPB that focused on other aspects, including in the area of health data, of data needed for research, and so forth. And I would say that right now we have avoided a situation where there is any major contradiction. Also because, and that's another lesson of this crisis, DPA have been closely associated to the decision taken by us as European Commission, but also taken by health authorities at national level. But of course, every day brings new issues. Before joining you, we were in a meeting where we were looking at what has been decided by some data protection authorities. I'm thinking most recently of the French and the Belgian one on the use of smart surveillance cameras as part of the exit strategy and the lifting of confinement measures to check whether people are wearing masks or keep social distance, temperature checks. That raises very important issues, and on this too, I think we will need to come with a common European response. If I have another few minutes, for us, meaning in terms of the broader picture, I think three main lessons. First, interestingly, this is the first time where there has been, as Julie was said, we all agree that privacy is important. There has been this realization, I would say, at global level, and for the first time, not in reaction to a scandal, a crisis. It's not Snowden, it's not Facebook Cambridge Analytica, it's not a massive data breaches. We'll talk about Schrems later on. It's privacy is really seen as part of the solution, as a necessity. To ensure trust, to ensure social acceptance, the uptake and effectiveness of those digital tools that we already mentioned that are essential to limit the spread of the disease, support effective exit strategies, but also continue simply ensuring the continuity of government and business operation. I think that's a very important message and quite a global message. The second the important message, and that was also, I think, present in what Keith and Julie said, confirmation of the validity of basic privacy principles that, in a certain sense, some of us were giving for granted. I'm referring in particular to those sort of privacy design principles, such as fairness, purpose limitation, transparency, data minimization, and others that have proved to be very relevant to develop the type of digital response to the crisis we have heard. And third, and certainly last but not the least, to come back to data protection authorities. Data protection authorities are an absolutely essential element of a successful privacy framework. In a certain sense, the success of the GDPR depends to a very large extent of how effective data protection authorities can be in terms, and I think we might discuss this in more detail, can be in terms of being able to react to a situation like this, adapt the interpretation of the rules in light of developments which could certainly not be foreseen even a few months ago, and come and contribute to the development of solution. And I think that all in all, European DPAs have shown that they can work together, and they have, we discussed this, they have even changed their working methods. And I think this will have a long-lasting consequence, and I would say a positive one, on beyond the crisis, on the way they will handle other issues.
Bruno, those three were very thoughtful. And maybe I'll turn it back to Keith and Julie. I know we could spend most of our panel today, but I want to, on this one issue, do you have 2 or 3 reactions to each other that you'd like to highlight on this issue? I, for example, and I don't want to focus this, like I worry from the employee perspective as you're reopening, how do you make sure, how is consent totally voluntary? How do you make it voluntary that you're doing this? Like, how does that become a choice? Because, you know, you're making a choice to go back to work, and it's going to be a choice that's not totally voluntary, I think, at the end of the day. That's what I worry about as a practical matter. But maybe there were reactions you had to Bruno's points. There's some very practical things we're seeing out of this that you all are probably seeing day to day.
Keith, you're on mute.
I was just saying, one thing that Bruno said that immediately resonates with me is watching the European privacy community react to the crisis and coalesce, I think sends an important message to the US right now for the need for a uniform omnibus federal privacy law. We require that same level of certainty, that same level of confidence in time of crisis, where we understand what the boundaries are, we have clear parameters within which to operate. And I sort of observed the same behaviors that Bruno is describing. Of course, it was a time of uncertainty. Of course, it was a moment of crisis, and folks came together, you know, with different positions. But I do think what we've seen across Europe is there has been sort of generally a coalescing around common guidance, around a common trajectory. That has allowed our project to advance. It's allowed us to sort of partner with national health authorities in a really productive way. And, you know, we're trying to do the same thing here in the United States, and with varying levels of success. But it really drives home for me. There's a lot of legislative interest right now in COVID-specific privacy laws, and that's fine. But we shouldn't lose sight of the fact that we would really benefit tremendously from a uniform federal law.
Yeah, I agree with that. You know, many of us have been calling for a federal law, or actually any, you know, broad and robust privacy law for many, many years. I do think that what we are seeing at least in the United States, is that it might have answered some questions and also calmed some concerns if we had had a privacy law in place, things like purpose specification and things like, you know, consent and other issues could have been a little bit clearer. I think what's kind of remarkable, so full stop, I actually think that we need a privacy law, and I think there have been more conversations around privacy laws now than I've seen in decades, and I've been involved in this space for quite some time. And so that's been very encouraging. Some of the conversations are around COVID-specific laws, some are around broader laws, and I think we will likely see much more movement in the coming months, if not in Congress, then certainly in the states. But what I'm also deeply encouraged about is that companies recognize they need to move forward. And while everybody wants clear guidance, and that's what we're calling for from policymakers, and it really is policymakers' roles to provide clear guidance, as well as regulators' clear roles, we're also seeing companies stepping up and saying, okay, we're going to create principles. Here's how we're going to do it, because companies understand that they have to be good stewards of data. They want their systems to be trusted. It won't work if it's not trusted, but also they want to demonstrate that we're going to be good stewards of data, and we can really construct these things in the right way. I think the employment context is one of the more interesting ones. And I do agree with you, Justin, that there's going to be complications around what does meaningful consent mean. I think that we're probably going to need to start thinking kind of a scaled approach to meaningful consent, at least in the United States. I think the DPAs would probably have a different view. But with respect to meaningful consent, if you're at a company where you're able to work at home or work remotely, you know that your company is going to be doing symptom checking, query whether you really do have an option to not have your symptoms checked. So that's one concept to think about, is how do you actually do meaningful consent when you have a remote work option, and then when you don't have a remote work option. When you don't have a remote work option, I think the other principles really need to be heightened even further. So in addition to transparency, I think that employers are going to need to really communicate with their employees very clearly that this data is only going to be used. You're going to get a red or a green about whether you can go into the office or the restaurant or the meat processing plant or whatever it is. We're only going to give, have a red or a green, and you can go in, or we're going to ask you to go home and until you feel better. The data will not be retained in any format that is personally identifiable, and it will be deleted or transformed into anonymized, aggregated data as quickly as possible, because otherwise we're going to run concern that people will say, this isn't fair, this isn't right. So communicating all of that to employees is going to be really, really critical for the meat packing plant, for the restaurant owners, for hotel operators, et cetera, as they start to roll out these symptom checkers. Bruno mentioned mask detectors. I mean, there'll be distance monitoring in some areas. We can do this. I do agree federal law would make it a lot easier, but I still think it's really important to always come back to what are your fundamental principles. And if you look at our principles, you mentioned, what we've put out publicly, robust transparency, get consent wherever possible, collect the data only for the specific purpose, minimize the data you're going to have, give choices to individuals about what happens to their data, make sure that it is deleted as quickly as possible and is only used for the public health purpose and is eliminated when the public health crisis is over. Those are the kinds of things we're going to need to put in place so that employees don't think, oh gosh, my symptom checking is going to now be going to determine whether I get a raise or whether I can keep my job. That's what we must avoid if this is going to be a trusted system.
No, I agree, Julie. And so let me say, as somebody now running a company where we're thinking about these things and we've been working remotely, I think just to be practical with our whole community here, I think if you take Julie's outline and Keith's outline and you look at some of the considerations coming out of the DPAs, it gives you a really good roadmap to put together a company policy. It really does, because you have to be specific about these things. And between those three pieces of guidance, if you start with what you all have been talking about in much greater detail, you can actually put together a company policy, quickly.
Yeah.
I'm sorry, Joe, go ahead.
No. I was just going to say, you're absolutely right, and you can put it together. Also, one of the things that we've, we're global, so we have sites all over the world. Some of which are back, everybody's back. Some of which are closed, including our headquarters in Washington State. But with those that are open, we are rolling out some of these systems now. These symptom checking lists, where we ask people, do you have any symptom or not? And we're following following what we're preaching here, and really trying to abide by these principles and be super clear with our employees and engage in all the other practices that we've been outlining.
Well, look, Julie, that's great. And so we're at that is, and it's meaningful for folks who are joining to get this guidance. On behalf of everybody, I will say both, Keith, Julie, Bruno, it really does help the community when you go talk about it. And we realize that even going to talk about it is risky. And it really is. You're out there on a limb. When you propose solutions like Google did, you're going to be criticized, right? That is a choice. And so the fact that you all are sharing insights and letting people model after it, it's really important for a lot of companies who might not have the resources to think about it quite as deeply. I'm going to take a lot of the questions. We're going to hold them because there are so many. And we have another subject that now Bruno will be the star of. Well, there's a fairly significant decision that's teed up, just to transition over to Schrems 2, the second decision, Bruno. There's obviously a lot to talk about. We only have a few minutes. So we have the European Court of Justice set to rule in July. It obviously impacts lawful transfer of data from EU. It could affect a lot of different things. And the Advocate General has already issued an opinion. So Bruno, do you mind giving us how about you get 3 sentences to summarize the entire status of Schrems and to give us your prediction of the outcome? I think that should be enough, Bruno. What do you think?
Yeah, well, the US is a country of opportunities and challenges. That's a challenge. Maybe just a few words, because I don't know, probably everybody has heard about Schrems. He is certainly very famous, but just a few words about the case, and then a few words about what could be the possible outcome of the litigation as we see them. So, because I'm not sure everybody has the same knowledge about the case. This is basically a case which is about the use of a certain transfer mechanism, standard contractual clauses. So those model clauses that companies can introduce in their contract with a number of safeguards to be able to transfer data from the EU to a third country. And here the case is about the use of these standard contractual clauses to transfer data to the US. And the questions that have been raised is whether when used to transferring data to the US, those clauses provide for sufficient safeguards in light of certain features of the US system, which according to the Irish DPA, which started, raised these cases on the basis of a complaint by Mr. Schrems, which according to the Irish DPA were not sufficient and or didn't provide the sufficient level of protection. We're talking here about aspects that concerns the conditioned limitation under which US authorities and US national security authorities can have access to that. And where the thing gets complicated is that while this case is about standard contractual clauses, it might also raise issues on the privacy shield, which is another transfer tool. And why is that? Because in the context of the privacy shield that I happily negotiated with Justin, we as Commission have assessed the US system in terms of national governance access in the area of national security. And we came to the conclusion that that system provided sufficient safeguards. And in the context of the negotiation, we also reached an agreement providing for additional safeguards, such as the ombudsperson mechanism, that a lot of you might have heard about, which apply across the board to all transfer tools, including those standard contractual clauses. By saying this, I realize it becomes complicated, but just to give the to be clear that there is an interaction between those transfer mechanisms, and that this case might concern either some of them or all of them. So there has been a hearing, there has been an opinion of what we call an advocate general, which doesn't bind the court, but gives an opinion from a very authoritative member of the court, a lawyer, saying, according to me, this case should be solved in this way. And a judgment date has now been announced for the 16th of July, so less than in 1 month. what could be the outcome of this pending of this case? Well, it basically the possible outcomes ranges from 0 to 10 in terms of impact, if I may say so. First outcome, the court might confirm that the Commission assessment of the U.S. Legal framework with regard to the access by the U.S. intelligence community complies with EU law. And that would mean that both the privacy shield and the standard control and the use and the standard the privacy shield would be valid. Standard contractual clause could continue to be used to transfer data to the US. In light of the hearing, of the opinion, of whatever, some observers have doubts that the outcome would be so positive, but that remains a possible outcome. Second possible outcome, the court might enter into an assessment of the safeguards provided by the US legal system as they have been analyzed by the Commission in the Privacy Shield decision, and find that these are not in line with EU law and with EU constitutional law, what we call the Charter of Fundamental Rights. This would probably lead to the invalidation of the Privacy Shield, could lead to the invalidation of the Privacy Shield. So second possible outcome could be the invalidation of the privacy shield. A third outcome would be that the court, and of course, I have no insight. This is a court decision, and those are just speculation, but that I'm sharing with you. A third possible outcome is that the court decides to, in a certain sense, focus on the general principles, clarify the general standard that applies to any transfer mechanism under the GDPR. And that standard would have to be further interpreted and applied to the concerned transfer mechanism, standard contractual clauses and privacy shield. And depending on how such a standard will be formulated, for instance, in the context or as regards judicial redress, how much or what type of judicial redress should be available in this area, then depending on how this is interpreted, it might have an impact on the privacy shield. It might have an impact on how standard contractual clauses can be used. It can have an impact on both the privacy shield or the standard contractual clauses, as well as other instruments, because, for instance, BCRs, binding corporate rules, are also play a similar role than standard contractual clauses are so-called appropriate safeguards. So you see the reach, the impact of this case could be quite far-reaching. And finally, there's a variation to this third scenario, where the court would, in a certain sense, set some or provide for some elements of interpretations that then would need to still to be applied by the Irish court. I will explain why, to the specific circumstances of this case. And that would mean that actually on the 16th of July, there would be a first decision, but then that will need to be followed up. Why is that? Because we have a quite complex system here, where national courts, so the courts of our member states, can make a so-called reference for preliminary ruling. They can ask the Court of Justice, exactly as it happened here, what is the interpretation of EU law that I should apply to my case? And that's why sometimes it's the Court of Justice that takes the final decision, for instance, if it would invalidate the privacy shield. In other cases, it might, in a certain sense, provide from some general interpretation principle that they need to be further applied by the national court concerned to the case pending before the national court. So those are the type of, and probably I've forgotten some scenarios. As I said, while explaining that, I realize how complex is that, but I hope I have managed to give a sense of the importance and relevance of this case.
No, it has, Bruno, and that was a really very short summary of a lot of different issues. So I'm going to ask you in a moment, just so you can prepare, what exactly is going to happen. And we're going to hold you to this. But I'm going to give Julie a moment to react because, you know, I want to at least get a prediction from you. Julie, do you and Keith, this could obviously be a very, very important case. There's outcomes here that get into some very technical issues around standing, for example, that could really blow things up. I think they're unlikely. But Julie, Keith, do you have a reaction to what Bruno just covered?
Well, as usual, Bruno gave a very thorough and intellectually sound analysis. So hopefully people were taking notes who need that kind of information. Just a couple of things I want to highlight, especially for those listeners who are used to the U.S. judicial system. First of all, this case is being heard by all 15 of the justices on the European Court of Justice. So it is, and the European system does not have a tradition of dissents. So all 15 of these justices need to agree on their decision, which is interesting. I also think it is one of the reasons why this decision has taken longer than anyone had expected. COVID may have played a role, but I don't think so, because it was at the beginning of the COVID crisis that the justices indicated that they were going to have a decision by summer, and also more recently they announced the decision would come out on July 16th. But it is interesting that no dissents are allowed. The other thing that happened in this case, and I think, Bruno, you alluded to this, but I just want to call it out. There was an advisory opinion that was issued. The court has a tradition of hearing from their advisors who issue advisory opinions. And in this case, the advisory opinion was interesting because I would say about 9/10 of it criticized Privacy Shield and raised questions about whether Privacy Shield was truly adequate, whether the European Commission had needs to revisit its decision, or whether the whole framework would need to fall. But the case was really about, as Bruno said, standard contractual clauses. And then in the last portion of the decision, the Advocate General who wrote this advisory opinion said standard contractual clauses can remain, but they need to be the way in which companies are implementing their standard contractual clauses need to be assessed first by the controller, or one could probably say in most cases the exporter, who needs to assess on a case-by-case basis whether their processor or the importer is appropriately complying with the standard contractual clauses and is providing a system that adequately protects Europeans' privacy rights. So it's very interesting that what the Advocate General was proposing was really a highly distributed, decentralized regulatory system, which in the first instance would be in the hands of controllers and then would move to DPAs if there were further questions that were raised. So that'll be interesting for those of us for whom this is a major way in which we operate, that is through standard contractual clauses. The third thing I'll mention is that standard contractual clauses are not just used to transfer data from Europe to the United States. They are used to transfer data from Europe to the rest of the world, including the United States. So what will be very interesting too to watch decision, the extent to which the court focuses in on standard contractual clauses generally as a mechanism that can be used to transfer data to anywhere in the world, and what are the requirements that are going to need to be put in place anywhere, versus focusing first and foremost and perhaps exclusively on what is going on in the United States and whether or not standard contractual clauses would be adequate to transfer data from Europe to the United States, and that will be the extent of the decision. But whether or not the court explicitly addresses rest of world, I think it'll be really important for everyone to understand that, companies in Germany and France and the Netherlands and, throughout Italy, everywhere in the European Union do rely on standard contractual clauses as one of their major means for engaging in global trade. And so this decision could have a very big impact, not just on the United States, or companies that are based in the United States and that need to transfer data from Europe to the United States, but it could also have a tremendous impact on worldwide trade from the perspective of European companies. So those are the things I would highlight, and we'll just have to see what the justices unanimously agree to tell us.
Julie, that was again very thoughtful, and there's a lot here. We're down to just the last 5 minutes. There have been a lot of questions that have come in, and I'm going to try to highlight a few, if you don't mind, for everybody. And then I'll close with maybe 2 questions. Just if you feel comfortable, each of the 3 of you, do you hear the 3? You can think about them and we'll come back to them at the end. Do you think we'll end up with a COVID privacy law within the next year? Do you think we'll have something that's at least narrow to a COVID privacy law in the US? Bruno, we won't put you on the spot. I don't know. I don't know if you feel comfortable weighing in on US law. And secondly, do you have a sense or a prediction of where we'll end up on Schrems 2? Just what's your sense of it, if you feel comfortable weighing in on those? Keith, you haven't, I'm going to pull a question that was directed, I think, more for you, if you don't mind. And that is, there's questions that on the COVID subject we covered before, which is not only about, imagine that that a company follows the rules and they're collecting the data, and imagine that your technology is used the right way for now. There was a question about the use of this technology for the longer term, and how are you all thinking about making sure that it won't later be used, these APIs, by app developers and others for things that we don't feel comfortable about? And
this is a fundamental question that we need to be as clear and explicit as possible in sort of giving folks a very clear understanding. These are limited use APIs. They are not generally available to app developers. In fact, individual health authorities may only approve a single app to prevent fragmentation, because we want to promote adoption, we want to optimize for user trust. So the APIs are only available to approved apps. They're going through a specialized approval process for the app stores, both on the Google side and the Apple side, to make sure that they're adhering to the very strict criteria that we are applying in terms of the kinds of consent they're getting, the appropriate uses of data, and the things that they're prohibited from doing, like calling device location information. So we're being very, very rigorous and very diligent in the application of the policies and the approval process for the apps. When the current health crisis passes, our intention is to deprecate the apps. The APIs, sorry. So we are going to be working with health authorities, and when we have an appropriate signal from them, we'll be turning down the APIs so the functionality won't be available. So we're addressing the very legitimate concern that the question frames in 2 ways. One, partnering with national health authorities so that only approved apps will ever have access to these APIs. And then secondarily, sunset the APIs at the end of the present crisis so that they don't live on and carry the risk of being repurposed for some nefarious use later on.
Thanks, Keith. That's really helpful. And this clarification helps a lot. Again, we're down to only a few minutes here, and I want to make sure if you have everybody, if you wanted to react to anybody, that you have a few minutes to do that. On both of these 2 very serious issues, obviously COVID-19 is on everybody's mind right now. I have seen almost the best of our community jump into a lot of different scenarios to help try to approach it with a problem-solving ethic. Like, how can we help? I'm hearing more, how can I help? How can I help think through the problem? And, to both Bruno and Julie, and Keith's point, this is kind of what privacy design is intended for. It's the idea that you have a very hard problem, and at its highest level, you're engaging with the experts on privacy protection at the moment you're building the thing, so that you can work together. And it's inspiring to me to see so many folks in our community leaning in with their own companies to say, hey, think about it this way, or to work, both Google and Microsoft, I know, are doing this, but to work with health authorities and public entities to say, this is the thing you need to know about this so that we can work on a tough problem together. It's really awesome. I mean, it's awesome. We have a long way to go, but I think it is awesome.
Yeah, just really quickly on your point, I agree. It's really been wonderful to see not just the privacy community step up, but I'm seeing a tremendous amount of activity within Microsoft among engineers. I'm sure, Keith, you're seeing the same thing. People trying to develop solutions across the board. I want to go back to something that you said earlier on, that you said, are stepping forward, Apple, Google stepping forward with their interoperable technical solution. Microsoft stepping forward to design principles about how we're going to approach any COVID digital technology that represents risk. To be honest with you, I think there's much more risk if we don't step forward. I think we have a responsibility, not just because we represent some of the largest companies in the world, but also because we have expertise. And we have the ability to sort of draw on, literally sitting just in this conversation right now, decades and decades of experience. We have a responsibility to step forward and at least offer our thoughts for people to consider. I don't think anybody has the right answer here. There really are no right answers. But what we can do is offer up ideas so people can start talking about them and saying, oh, this is what Google's saying. Oh, Apple, oh, Microsoft's saying this. Oh, the DPAs are saying this. So that we can quickly come to consensus. And actually, to your point, Justin, that's what I'm seeing. There really is a lot of consensus. Around the edges, there's always going to be a conversation, but I see a lot of consensus about the core needs of how we're going to need to be addressing both the need to use data and how we're going to protect that data, because we absolutely have to do that too.
I completely agree, Julie. Keith and Bruno, I want to give each of you a moment to just react, and then if you feel comfortable answering the questions I asked, I'd love to hear it.
Yeah, well, on Schrems, I'm the Schrems expert. Very quickly, three things. First, why the court has taken some time, and indeed, this is not linked to COVID, and we can only speculate on that. But I think it is also because those are very complex and very important issues. And in this litigation, almost any possible arguments has been put forward. It was extremely interesting. And that's also, I would say, a sign of the importance of privacy issues, that in this litigation, a very wide range of institutional actors and stakeholders intervene. Us, as Commission, of course, member states, EU member states, the US government. I think that was the first time that the US government intervened in a case before the European Court of Justice, the European Data Protection Board, business associations, civil society organizations. So whatever the court will decide, and actually decides, it's a majority vote, it will decide on the basis of a lot of information, on a lot of arguments. This will be a very informed decision. Second, I cannot tell you, I cannot predict what will be the decision of the court, but I can tell you a bit of how we are preparing ourselves to that decision. This would require a lot of time, but one thing that we're doing is that we are currently reviewing a standard contractual clause and preparing a new set of standard contractual clauses. Not only because of the litigation, those clauses need to be updated anyway, but I can confirm what Julie was saying. Standard contractual clauses are the most widely used transfer tool. They are extremely important. We are fully committed to have a system that ensures both a high level of protection and is open to data flows. We don't think that this is contradictory. On the contrary, we think that those are two complementary, two sides of the same coin. If you want data to flow, it has to flow on the basis of sufficient safeguards. So that's, for instance, something very concrete we are working on